You're listening to the Valley Current.
Usually when we talk about medical diagnosis, there's this expectation of clinical precision.
Right.
Like you break your arm, the x-ray shows that jagged white line on the radius, and the doctor just points at the film and says, there's the fracture.
Yeah, it's very binary.
Exactly. Broken or not broken.
Right.
It's comforting because it's visible, right? You can categorize the physical world with absolute certainty.
You know where you stand.
But if you step into the world of intellectual property right now, specifically around artificial intelligence, machine learning, and, robotics, that x-ray machine is just completely broken.
It really is. It's a mess.
Tech companies are spending literally billions of dollars to build these massive world-changing systems. But the federal courts are quietly deciding that those same companies don't actually own most of what they're building.
Which is terrifying if you're an investor.
Oh, absolutely. So, okay, let's unpack this. I want you to imagine 4 massive fences. These fences are built around a central yard, and that yard is it's a you can't own this zone of ideas, the public domain.
The commons, yeah.
Right, the commons. Over the last decade, judges across the federal circuits have been aggressively moving all 4 of those fences outward.
Pushing the boundaries back.
Exactly. They're expanding that public yard. And it turns out that ever-expanding public yard is exactly where modern AI and humanoid robots live.
The visual of the fences actually captures the tension perfectly, because we are witnessing a monumental shift in the federal judiciary that is basically reshaping the foundational economics of technology.
Yeah.
If you are running a tech company right now, or even just building apps on the weekends, this shift in the courts is going to dictate what you can actually monetize and what you can protect.
And that is exactly our mission for this deep dive. We're looking at a deeply researched, just fascinating newsletter dated May 27, 2026.
It's a great piece.
It really is. It's from computer law group CLG.
Yeah.
Authored by their managing partner, Jrusso. And the title poses this explosive question. It's, are the federal courts enlarging the public domain in the age of AI and robotics?
A question a lot of founders are asking right now.
Yeah, sweating over, probably. So we're going to tear into Russo's thesis that 4 distinct intellectual property doctrines are simultaneously pushing more and more technology into the unowned commons. Mm-hmm. We're going to explore what happens when billion-dollar investments collide with, centuries-old legal limits, and what builders and defenders actually do when the traditional IP playbook just stops working entirely.
To really understand the stakes here, we need to look at those 4 fences you mentioned.
Yeah, lay them out for us.
You're dealing with copyright, patent, trade dress, and trade secrets.
The big 4.
Right. And the conventional wisdom for the last, 40 years of software development was that you layer these protections.
Like a moat.
Exactly. You copyright your source code, you patent your novel algorithms, you trademark your user interface, and you lock the back end up as a trade secret.
Which sounds like an impenetrable fortress, right?
It did. It really did. Until the technology fundamentally changed.
Right.
The CLG newsletter points out that each of these 4 systems has a built-in defensive limit, like a hard boundary designed to stop rights holders from monopolizing the basic, fundamental building blocks of human progress.
Okay, so give me an example of those limits.
So in copyright, you cannot protect a procedure or a method of operation.
Okay.
In patent law, you cannot protect an abstract idea.
Makes sense.
In trade dress, you can't protect a product feature if it's purely functional. And in trade secret law, your protection just vanishes the second the information becomes readily ascertainable by the public.
Wait, so these aren't the weapons a company uses to sue a competitor. These are the shields a competitor holds up when they get sued.
That is the absolute crux of it. They are defensive doctrines.
Oh, okay.
And to understand why these defensive shields are suddenly winning so much ground in the courts, we have to look all the way back to the United States Constitution.
Wait, really? The Constitution?
Yeah, Article 1, Section 8, Clause 8, the Progress Clause.
I didn't even know IP was in the Constitution.
Oh, it's foundational. The framers authorized Congress to grant exclusive rights for a very specific instrumental reason. The exact wording is to promote the progress of science and useful arts.
Huh. I think most people, you and me included sometimes, we assume IP law exists solely to make sure artists and inventors get rich off their hard work.
Right, like a moral right.
Yeah, it's a fairness thing, right? You build it, you own it.
That's the popular narrative for sure. But the underlying legal philosophy in the U.S. is entirely utilitarian.
Interesting.
The financial reward to the creator is just the mechanism used to achieve the actual goal, which is the advancement of society.
So it's a bribe, basically.
Essentially, yeah. We give you a temporary monopoly so that society gets the invention.
Wow.
But if granting a monopoly on a fundamental tool, say, a mathematical algorithm or a basic method of organizing data, if that impedes innovation more than it promotes it, the courts will strike that monopoly down.
Because it violates the core constitutional purpose.
Exactly. The public domain has to be preserved so the next generation of engineers has raw materials to actually build with.
That makes historical sense. But looking at the CLG newsletter, it highlights this massive convergence happening right now.
Yeah, it's a huge shift.
Why are judges seemingly siding with defendants and expanding these public boundaries over the last 10 years specifically? I mean, why didn't this happen during the dot-com boom?
It's a great question. The timing is directly tied to the architecture of the technology itself.
How so?
Well, think about the dot-com era. It was about web pages and e-commerce.
Shopping carts, text, images.
Right. Things that fit relatively well into traditional copyright and patent buckets. A web page is basically a digital magazine.
Yeah, pretty straightforward.
But over the last decade, we've seen the hyperscale diffusion of cloud computing, deep learning neural networks, and, humanoid robotics.
A totally different beast.
Completely. These technologies naturally straddle the line between creative expression and functional utility.
So it's a hybrid problem. Like when you write a fantasy novel, it's pure expression.
Right.
When you forge a wrench, it's pure function. But what is a billion-parameter neural network?
Exactly.
What is the physical shape of a robot designed to carry boxes up a flight of human stairs?
Right. They are expressive. Yes, there is design there, but their entire purpose is to do something.
They act on the world.
Yes. They are highly functional. And because they are functional, they just keep triggering those built-in constitutional defense mechanisms across all 4 IP regimes simultaneously.
Oh, I see.
The courts aren't suddenly becoming like anti-technology.
Right, it's not a bias.
No, they are just applying centuries-old rules designed to keep functional methods in the public domain to a new wave of highly functional digital and robotic artifacts.
Okay, let's test this theory against the first fence, which is copyright.
Let's do it.
If I write a million lines of code for my new AI startup, I naturally assume I own that code under copyright. That's mine. But the statute, specifically 17 U.S.C. Section 102B, explicitly excludes any idea, procedure, process, system, or method of operation.
That's the boundary.
So if my code is just a method, where is the line? I was so fascinated by the newsletter's approach here. To understand the future of artificial intelligence copyright, we don't look at a supercomputer.
We look at a fitness DVD.
A celebrity fitness DVD. It's wild.
The legal through line there is incredible. It really is. To figure out where the boundary of a method actually lies, the newsletter anchors us to a Ninth Circuit decision from February 17th, 2026.
Okay.
The case is Tracy Anderson v. Roop.
Tracy Anderson, the massive celebrity fitness brand, right?
Exactly. They created these carefully sequenced, dance-influenced workout routines, ballet, hip-hop, jazz movements, all stringed together in a very, very specific order.
Right.
They registered the DVDs of these routines with the Copyright Office, and then they sued a former instructor, Megan Roop, who had launched a competing fitness brand using comparable routines.
Now, on the surface, if I choreograph a dance and film it, I own the copyright to that visual expression. It seems like an open and shut case for infringement. She worked there, she took the routines, she started a competitor.
You'd think that, absolutely. But Tracy Anderson lost the copyright claim.
Wow.
And the reason why reveals everything about how Section 102B operates in the real world. The court didn't just look at the movements on the screen, they looked at how Tracy Anderson's brand actually marketed those DVDs to the public.
Oh, interesting. What did they say?
They called it the Tracy Anderson method.
Ah.
They explicitly promised consumers that following this specific rigid sequence of movements would produce a tangible result: a transformed body, optimal calorie burning, muscle lengthening.
So they essentially stepped on a landmine of their own making.
Pretty much.
They marketed it as a functional tool rather than an artistic performance.
The court essentially looked at it and said, "We believe your marketing." By calling it a method designed to attain identifiable physical results, the creator admitted the sequence wasn't just artistic expression, it was a utilitarian system.
That is brutal.
And the moment something is classified as a system or a method, Section 102B violently strips away the copyright protection for the routine itself.
The newsletter uses this fantastic analogy about baking to explain this.
I love this one.
You can copyright the text of a cookbook.
Yeah.
The specific words you use, the stylized photographs of the cake, the typography, the layout that is your creative expression.
Yes.
But you cannot, under any circumstances, copyright the recipe itself.
The method.
Right. The steps to bake the cake are a method. If I buy your cookbook, memorize your recipe, and go open a bakery using your exact steps to sell cakes, I am not infringing on your copyright.
Exactly. The courts are incredibly strict on this division between the description of the method and the method itself.
Has this come up in other fitness cases?
Oh yeah, the Ninth Circuit had laid the groundwork for this back in 2015 with the Bikram yoga case.
The hot yoga guy.
Right. Bikram Chowdhury tried to claim copyright over his sequence of 26 yoga postures practiced in a heated room.
He tried to own the actual order of the stretches.
He did, and the court looked at it and said, no, this is an idea or a process designed to improve health. You can copyright the book describing the poses, sure, but the sequence itself is uncopyrightable.
But wait, choreographers copyright dance moves all the time, right? People sue over TikTok dances. How does the court distinguish between a fitness routine and a dance?
That's a vital distinction. The newsletter contrasts the fitness cases with a 2023 case, Hanagami v. Epic Games.
Oh, the Fortnite case.
Exactly. A choreographer sued the makers of the video game Fortnite because they allegedly copied his expressive dance routine and turned it into an in-game emote that players could purchase.
And what happened there?
In that scenario, the court recognized it as potentially protectable choreography. The distinction is razor sharp here. The Fortnite dance was selected and arranged purely for aesthetic, artistic effect.
It's meant to look cool.
Right. It didn't exist to burn calories or align a spine. The fitness routines and the yoga sequences were arranged for an instrumental, physical result. So aesthetic expression gets a copyright. Functional methods go to the public yard.
Okay, let's take this fitness DVD logic and aim it directly at large language models.
Here we go.
Because this is where the billion-dollar lawsuits are playing out right now. When an LLM like ChatGPT or Claude trains on millions of copyrighted books and articles, the authors are screaming, you copied our books.
Which is an understandable reaction.
Sure. But what is the AI actually doing from a technical standpoint, and how does that Section 102B method rule apply to it?
This is the absolute battlefield right now. The rights holders argue that the AI companies are making unauthorized copies of their protected expression. They're downloading the books to a server. But the tech companies, the defendants, argue that the AI is not copying the literal creative expression to regurgitate it. An LLM isn't memorizing the specific paragraphs of a Stephen King novel, so it can just reprint The Shining.
Right. It's breaking down the text into tokens and calculating the statistical probability of which word comes next. It's math.
It's pure statistical extraction. It's learning the syntax, the grammar, the patterns of human language, the structural relationships between concepts.
The recipe.
Yes. In the eyes of the law, extracting those patterns is extracting a method or a system. The AI is reading the cookbook to learn the underlying rules of baking. It isn't stealing the photographs of the cake.
And the courts are actually buying this argument. Like, judges agree with this.
Increasingly, they are. The newsletter details a massive 2025 ruling by Judge Alsup in the Northern District of California. It's Bartz v. Anthropic.
Oh, this is a huge case.
Massive. The judge explicitly called the act of training an AI model on lawfully acquired texts quintessentially transformative.
Transformative, that's the magic word.
Right. Now, transformative is technically the language of fair use, but conceptually, it's doing the exact same work as our Section 102B rule. The model is learning the system, not copying the expression.
Let's linger on that Bart's case for a second, because the newsletter mentions a staggering $1.5 billion settlement attached to it.
Yeah, that caught a lot of people by surprise.
If the judge ruled that training is transformative, why did Anthropic end up paying the largest copyright settlement in U.S. history? It seems contradictory.
It does seem that way, but it makes sense when you look at the details, because Judge Alsup drew a very hard, brilliant line regarding the source of the training data.
Ah, where they got the books.
Exactly. He ruled that extracting the method is fair use, but only if you are extracting it from lawfully acquired copies.
Okay.
You buy the book, you scan it, you train on it, that's transformative. But the plaintiffs proved that a massive portion of the training data came from shadow libraries.
Shadow libraries?
Yeah, illegal, pirated torrents of copyrighted EPUBs and PDFs, millions of books downloaded from illicit servers.
So the fair use defense collapses if you break into the bakery to steal the cookbook in the first place.
That is precisely it. The judge deemed training on pirated materials inherently irredeemably infringing.
Irredeemably infringing. Wow.
Yeah, he didn't hold back. The $1.5 billion settlement, which got preliminary approval in late 2025, resolved the piracy side of the litigation.
Just the piracies.
Right. But, and this is vital for the future of the industry, the settlement did not invalidate the core premise. Learning the method of language from legal copies remains completely permissible.
Okay, so the input mechanism, the training phase, is largely being viewed as learning an uncopyrightable method, provided you don't pirate the books.
Correct.
But what about the output? Because if I spend, 6 hours carefully crafting the perfect multi-page prompt, tweaking the parameters, and the AI generates a beautiful short story or a functioning app, I want to copyright that. I put work into it.
That's a very common feeling among prompt engineers right now. But the U.S. Copyright Office and the federal courts have entirely shut the door on that.
Completely shut it.
Completely. The newsletter covers the 2025 case Thaler v. Perlmutter. Stephen Thaler tried to register an artwork created entirely by an AI system he owned.
I remember seeing this on the news. It was that wild algorithmic painting.
Yes. And the D.C. Circuit Court of Appeals affirmed that the Copyright Act of 1976 fundamentally requires all eligible works to have a human author.
A human author.
Right. Pure AI-generated output, regardless of how complex the prompt was, lacks human authorship of the final expression. The Supreme Court even declined to hear the appeal in March 2026.
So that's the final word.
It is. So the output of an AI falls straight into the public domain yard. You can use it, sure, but you can't stop your competitor from copy-pasting it the second you publish it.
So the output is totally unowned. I want to make sure we don't paint with too broad a brush here, though, because the CLG newsletter points out an exception where the tech companies did lose on fair use, and it actually wasn't about piracy.
Right, the Thomson Reuters case.
Yes, Thomson Reuters v. Ross. How does a non-generative AI change the calculus for fair use?
That case, from early 2025 in Delaware, provides the perfect counterexample to the LLM situation. Ross Intelligence built an AI legal research tool.
Okay.
But instead of training a massive generative model to understand the structure of language from scratch, they basically scraped highly proprietary, heavily edited legal headnotes from Westlaw.
So they just took Westlaw's organized database.
Basically. And they used AI as a search engine for it to build a direct competitor. The judge ruled against Ross, explicitly noting, and this is a quote, "Only non-generative AI is before me today."
So they weren't learning a method. They were just lifting someone else's curated database and serving it up.
Right. If your AI isn't transforming the data into a new generative capability, but is essentially just copying and serving up specialized proprietary text to compete in the exact same market, fair use won't save you.
Okay, that makes sense. So the first fence, copyright, has been pushed way back.
Way back.
It won't protect the method of a fitness routine, it won't stop an AI from learning the method of language from legal texts, and it won't let you own the output the AI generates. Nope. If I'm a tech founder and I realize my brilliant new AI system's core method can't be copyrighted, my immediate instinct is to pivot.
Oh, of course.
I'll just say, fine, I'll patent the software architecture instead. The patent office is supposed to protect inventions, right?
Does the second fence offer a better shield?
Oh man, for software developers, the second fence has become a notorious, almost insurmountable trap.
A trap?
You are walking right into 35 U.S.C. Section 101.
Okay, let's break down Section 101. The statute says you can patent any new and useful process, machine, manufacture, or composition of matter.
Sounds great, right?
Yeah, it sounds broad enough to cover AI. What's the trap?
The trap lies in the judicial exceptions. Over the decades, the Supreme Court has ruled that you cannot patent laws of nature, natural phenomena, or abstract ideas.
Abstract ideas.
Yes, and for AI and software, that last category, abstract ideas, is an absolute legal meat grinder.
A meat grinder.
The framework the courts use to evaluate this is known as the Alice-Mayo two-step test, named after two landmark Supreme Court decisions. How does this two-step test actually work in practice? Like, if I bring a machine learning algorithm to the patent office tomorrow, what hurdles do I have to clear?
Step 1 asks, Is the patent claim directed to a judicial exception, like an abstract idea? And for the vast majority of software patents, the courts say yes.
Just automatically?
Pretty much. They view algorithms, mathematical models, and organizing human activity as abstract concepts.
Okay, so what if I fail step 1?
If you fail step 1, and you almost certainly will, you are forced into step 2. Step 2 asks, is there an inventive concept that transforms this abstract idea into something patent eligible?
So did I add something extra?
Right. Did you add something significant that makes it more than just, do this known math on a computer?
That sounds highly subjective. And according to the statistics in the newsletter, the survival rate is abysmal.
The data is incredibly stark. The newsletter cites a comprehensive data set tracking Federal Circuit cases from 2014 to 2020. Software patents faced an 82.1% ineligibility rate at step 1.
82%?
Yeah. And if you hit that first step, your patent was almost guaranteed to be invalidated.
That is brutal.
Yeah.
But AI is supposed to be the new frontier, right?
Yeah.
It isn't just the 1990s spreadsheet sorting names. Surely the courts look at complex machine learning architectures differently than they look at basic data sorting.
You would hope so. But an anchor case from April 2025 proves otherwise. The Federal Circuit handed down a massive decision in Recentive Analytics v. Fox.
What happened there?
Recentive had developed a machine learning model to optimize event scheduling and content recommendation, basically predicting the best time to air television broadcasts.
Okay, very useful for a network.
Very useful. They patented it and sued Fox.
And the Federal Circuit killed the patent.
They absolutely gutted it. The court ruled that taking generic machine learning and applying it to a new specific field like event scheduling is an abstract idea.
Just an abstract idea.
It failed step 1 and it failed step 2 because there was no inventive concept beyond just applying a known statistical tool to new data.
The newsletter uses a classic patent law analogy to explain this. The mousetrap. Let's walk through that because I think it clarifies the court's logic perfectly.
It really does. So in patent law, you cannot patent the general idea of catching mice.
Right. That's a goal.
That's an abstract goal. What you can patent is a specific, novel physical contraption with springs, a wooden base, and a catch mechanism. A specific mousetrap.
Okay.
After the Alice decision in 2014, the courts basically said, you can't just take the abstract idea of catching mice, add a microprocessor, and claim a patent on catching mice using a generic computer.
Because you haven't invented a new trap. You've just automated the abstract idea.
Exactly. And what the 2025 Recentive decision did was add the final modern layer to that analogy. The court said, you also cannot patent the idea of catching mice using generic machine learning.
Oh, wow.
Pointing a neural network at a scheduling problem is not a patentable invention. It's just using a modern calculator to do abstract math faster.
If I'm an investor and a startup tells me they spent $50 million trading in AI to perfectly optimize, global shipping logistics, and the court looks at it and says, sorry, that's just generic ML applied to a new field. Invalid. I'm panicking.
It's a scary reality.
If almost everything fails this test, how do you actually protect an AI invention? What does the playbook look like for a founder who actually wants to secure a patent?
The newsletter provides the exact playbook drawn from the U.S. Patent and Trademark Office's 2024 AI Subject Matter Eligibility Guidance.
Okay, so the USPTO actually told people how to do it.
Yes. To survive the Section 101 trap, you have to fundamentally shift what you are claiming. You cannot claim the application of the AI. You must claim a highly specific technical improvement to the machine or the model itself.
Give me the engineering reality of that. What passes the test?
So the USPTO provided concrete examples to guide examiners. Example 47 in their guidance involves an artificial neural network specifically designed for anomaly detection. But the claim doesn't stop at the software layer. The patent claims the physical integration of that network into an application-specific integrated circuit, an ASIC chip.
Oh, so hardware.
Exactly. The physical architecture of the chip is optimized for the specific data flows of that network.
So you aren't just claiming the math, you are claiming a novel hardware-software fusion that improves how a physical machine operates.
That's the secret. Another example they gave was example 49, a hands-free voice recognition system.
Like Alexa or something.
Right. But again, you can't just patent using AI to transcribe voice. The eligible patent claimed a specific, novel algorithmic method for separating speech from background noise at the hardware microphone level before it hits the NLP processor.
Before it hits the software.
Right. You have to invent a tangibly better mechanical mousetrap. You can't just point an off-the-shelf LLM at a new room full of mice.
Wow. So the courts are aggressively pushing generic AI applications into the public domain, ensuring no one can build a patent monopoly on the basic toolset of the 21st century. Which brings us to the physical hardware. We've looked at the invisible stuff code, algorithms, methods. But what happens when we move out of the cloud and into the physical world?
The fun stuff.
Right. The robotics industry is exploding. If I spend 4 years designing a humanoid robot, and it has an incredibly sleek, unique, futuristic silhouette, I want to lock down its appearance so a competitor can't just clone my design. Does the third fence trade dress protect me?
This is where the physical geometry of robotics hits a massive legal wall known as the functionality doctrine.
Okay, so trade dress usually protects the aesthetic look and feel of a product. If I see a robin's egg blue box, I instantly know it's from Tiffany's. That blue color is a source identifier.
That tells you the brand.
But there's a limit, right? It instantly evaporates if that look is functional. Which brings us to the headache of robotics.
The absolute prerequisite for trade dress protection is that the feature must be non-functional. The Supreme Court cemented this in 2001 in Traffic's devices.
And what did they say?
They held that if a product feature is essential to the use or purpose of the device, or if giving you exclusive rights to it would put your competitors at a significant non-reputation-related disadvantage, then that feature is functional.
Okay.
And if it's functional, you cannot monopolize it.
The newsletter highlights a 2021 Second Circuit case, Sulzer Mix Pack, to show how extreme this functionality test can be. Let's break that down, because it involves something incredibly mundane, dental mixing tips, but the legal shockwaves are huge for tech.
It's a great case study. Sulzer manufactured dental mixing tips. You know, the little plastic nozzles dentists attach to syringes to mix composite materials.
Like for fillings and stuff?
Right. To make things efficient, Sulzer color-coded the tips based on their diameter. Yellow for the small size, teal for medium, blue, pink, and so on.
Just a helpful system for the dentists.
Exactly. And over time, dentists came to associate those specific colors with Sulzer's products. So Sulzer tried to register those specific colors as their trade dress, arguing, these colors are a brand identity.
But wait, color is inherently aesthetic. It's not a gear or a lever. Why wouldn't they get trade dress for that?
Because of the context of the supply chain and the end user. The Second Circuit ruled the colors were functional because they communicated vital utilitarian information to the dentist. The diameter of the tip.
Oh.
If a competing manufacturer wants to enter the market and sell replacement tips, they need to be able to use the exact same color coding system. Otherwise, a dentist reaching for a tip during a procedure wouldn't know which size they were grabbing.
So even though the color was an aesthetic choice initially, it became a functional standard required to compete in the market.
Right.
Therefore, it cannot be monopolized.
Exactly. Now, take that rigid functionality standard and apply it to the current wave of robotics.
Right.
You have Boston Dynamics with Atlas, Tesla has the Optimus robot, you've got Figure 02, Agility's Digit. They are all starting to look surprisingly similar.
That's the billion-dollar question. Can Tesla or Boston Dynamics own the silhouette of a bipedal robot?
The short answer under this expanding doctrine is no. A humanoid robot requires 2 legs, 2 arms, a torso, and a head. Not because of arbitrary branding choices, but because that is the physical geometry required to navigate an environment built by and for humans.
It has to fit through our doors.
Yes, it needs those specific knee joints to walk up standard stairs, and it needs articulated hands to turn standard doorknobs. The silhouette is entirely dictated by the laws of physics and the requirements of the task.
The newsletter includes a fascinating footnote about a patent and trade dress dispute between Boston Dynamics and Ghost Robotics over quadruped robot dogs.
Yeah, that settled in early 2025.
Right. But the author uses it to foreshadow exactly what's coming.
Because as quadrupeds and bipeds become more common, their designs are going to naturally converge. Think about consumer drones. A drone with 4 rotors is shaped like an X.
Yeah, they all look the same.
It's not shaped like an X because the DJI thought it looked cool. It's shaped like an X because of aerodynamics and motor balance. A robot dog's legs are configured a certain way for stability on rough terrain.
Function over form.
Exactly. The courts are signaling very clearly you cannot use trade dress to build a legal moat around the physical geometry of your robot.
So what can a robotics company protect?
Arbitrary branding elements. You can trademark the name Spot or Optimus. You can slap a highly distinctive, non-functional neon green logo on the robot's chest plate.
Like a racing stripe.
Yeah, you could perhaps protect a specific ornamental color accent on the casing, assuming it doesn't signal anything functional, unlike those dental mixing tips. But the bipedal body itself, the physical chassis, that belongs in the public yard.
Okay, let's recap where this leaves a founder. We've hit 3 fences.
Yeah.
If I build an amazing AI robot, I can't copyright the method of its behavior or its training data. I can't patent the generic software driving it unless I physically tie it to a new hardware improvement. And I can't claim trade dress over its functional humanoid shape.
You are running out of options.
The walls are closing in on traditional IP. So if I'm a CEO, my last resort is to just pull the plug on transparency. I'm going to lock everything in a server room, refuse to publish any papers, and rely entirely on trade secrets. I'll just hide how it works.
That is the natural pivot, for sure. But, as we'll see with the 4th fence, keeping a secret in the modern digital age is exponentially harder, and the legal standard is incredibly unforgiving.
This brings us to trade secrets and the Federal Defend Trade Secrets Act, the DTSA. What are the actual rules here? Because I think a lot of companies assume that they don't tell anyone it's legally a trade secret.
The DTSA requires you to satisfy 2 major hurdles simultaneously. First, you must take reasonable measures to keep the information secret.
Guard the vault.
Exactly. You have to guard the vault. This means strict non-disclosure agreements, partitioned server access, physical security, employee training protocols.
That seems standard. What's the trap?
The trap is the second requirement. The information must not be generally known to or readily ascertainable through proper means by the public or your competitors.
Okay,
Yeah.
readily ascertainable.
Right. If a competitor can figure out your secret by looking at your product, reverse engineering it, or reading a public document, the law immediately vaporizes your trade secret protection. The law does not protect you from someone legitimately figuring out how you built your tool.
The newsletter points to an anchor case from 2022 called Turret Labs. How does that illustrate this readily ascertainable vulnerability?
Turret Labs is the perfect example of the visible functionality trap. Turret built proprietary cargo shipping software.
Okay.
They went to great lengths to protect the source code's server cages, strict logins, typical reasonable measures. But they sued a competitor for stealing their trade secrets, claiming that the functionality of the software itself, the way it organized data and generated workflows, was the secret.
And what did the court say?
The Second Circuit threw the case out entirely.
Why? They had server cages. They protected the code.
They protected the code, but the functionality they were claiming as a secret was completely visible to any downstream user who logged into the user interface.
Oh, because they were using the software.
Yes. Turret hadn't required those end users to sign non-disclosure agreements. The court ruled that if you expose the functionality of your software to the public without contractual protections, you haven't taken reasonable measures, and the secret is readily ascertainable just by watching the software work.
So if a user can see it working and they aren't under an NDA, it's not a secret.
Period.
That's a huge blind spot for SaaS companies. But I want to get into the most dramatic example in this entire newsletter. This really blew my mind because it involves a catastrophic mistake by one of the biggest AI labs in the world.
I know exactly what you're talking about.
Talk to me about the massive leak that happened on March 31st, 2026, involving Anthropic and their Claude code.
It is a staggering real-world example of rapid, irrevocable trade secret destruction. Anthropic pushed a seemingly routine software update to a public registry called NPM, which developers use to manage code packages.
Okay.
But in that deployment, they accidentally included a massive file called a source map.
Now, for the non-engineers listening, what is a source map and why is it so dangerous to leak?
So when you deploy complex software to production, you minify the code to make it run faster. You strip out all the spaces, rename the variables to single letters, and compress it into an unreadable brick of text.
Just to save space.
Right. A source map is essentially the decoder ring. It translates that minified, unreadable production code back into the original, pristine, human-readable source code written by the developers, complete with their internal comments and file structures.
And how much code did they expose?
The file was nearly 60 megabytes. It exposed approximately 512,000 lines of Anthropic's internal proprietary TypeScript.
500,000 lines of code.
Yes. And it wasn't just old infrastructure. It revealed unreleased feature flags, internal background agents they were developing, and internal system instructions, including something labeled undercover mode.
Oh my God.
Within hours, the developer community found it. It was mirrored on GitHub, downloaded thousands of times, dissected on Hacker News, and viewed by tens of millions of people before Anthropic realized the mistake and pulled the file down.
Okay, here is where I have to push back, because I'm putting myself in the shoes of Anthropic's lawyers.
Sure.
It was an accident. It was a deployment error. They pulled it down the same day. Can't they go to a federal judge, file an emergency injunction, and say, look, we obviously didn't mean to publish our core IP. It was a mistake. We are retroactively declaring this a secret again, and anyone who uses it or hosts it is stealing.
You would think equity would allow for a fix, right?
Right.
But that is the tragic reality of trade secret law. You cannot unring the bell.
Really, no exceptions.
None. The newsletter uses an incredibly relatable analogy. Imagine you have a secret family recipe, guarded for generations. One night, by mistake, you post it on a public Reddit forum. You realize your mistake 5 minutes later and furiously delete the post.
But in those 5 minutes, 1,000 people took a screenshot.
Exactly. The law looks at that situation and says, we're sorry, but the cat is out of the bag. The information is now readily ascertainable by the public. It does not matter that it was an accident.
Yeah, it is unforgiving.
It does not matter that you patched the software update an hour later. Real-time trade secret destruction at scale is a unique peril of the digital age. You can fix the leak to prevent future code from spilling, but you cannot retroactively re-secret the 500,000 lines of code that just hit the internet.
The newsletter brings in another case to reinforce how absolute this rule is. Massimo v. True Wearables.
Yes, Massimo proves that the courts offer no leniency here. In that case, a medical device company tried to claim trade secret protection over a specific algorithm used in their wearables.
Okay.
But during discovery, it turned out the core algorithm had been published in a dense academic paper cataloged by the IE years earlier.
Oh, no. Okay.
The Federal Circuit said once it's published in a public repository, it is ascertainable. It completely destroyed their trade secret claim.
This has massive implications for the AI industry right now, especially around the debate between closed models and open source models.
It really does. If a company releases an open weights model where anyone can download the neural network's parameters, like Meta does with Llama or what we see with DeepSeek, they are intentionally forfeiting trade secret protection over those weights by definition.
Because it's public.
You are handing the mathematical recipe to the world. You can't later claim someone stole your trade secret if you published the weights on Hugging Face.
So we've walked through the perimeter. We've seen all 4 fences pushed outward.
Yeah, they've moved significantly.
Copyright Section 102B excludes functional methods. Patent Section 101 excludes abstract machine learning ideas. Trade dress excludes functional robotic designs. And trade secret law demands absolute, unforgiving secrecy, penalizing any leak or visible functionality.
That's the landscape.
The courts are aggressively expanding the public domain. And as I listen to this, looking at the macro implications, if I'm a massive tech conglomerate or a scrappy AI startup, and the law is systematically stripping away my intellectual property protections left and right, won't this destroy the financial incentive to build these systems in the first place?
That's the million-dollar question.
Right. Why spend $1 billion training a frontier model if the courts won't let you own the method, the patent, or the design?
That is the exact argument being raised by rights holders, politicians, and legacy IP advocates right now. And the CLG newsletter does a great job of objectively laying out this massive incentive debate that's currently raging in Washington.
Let's look at the critique. Who is pushing back against this expansion of the public domain, and what is their actual argument?
On the copyright side, you have groups like the Authors Guild who fiercely criticize Judge Alsop's ruling in the Bartz case.
Because of the fair use ruling.
Right. They argue that letting AI train on books for free ignores decades of precedent and functionally harms creators by allowing machines to replace them.
Okay.
On the patent side, the pushback is even more structural. You have politicians like Senator Tom Tillis, who introduced the Patent Eligibility Restoration Act, or PERA, back in 2025.
And just to be clear to our listeners, we aren't taking a political stance on PERA or any legislation, left or right. We're just analyzing the arguments and facts presented in the source material. What is the theory behind PERA?
Understood. The theory advanced by the sponsors of PERA is a classic incentive argument. They argue that the Supreme Court's current patent eligibility jurisprudence, specifically the Alice test that kills 82% of software patents, is fundamentally undermining American innovation.
Because if you don't reward the inventor, they stop inventing.
Exactly. Their concern is that by pushing so much critical technology into the public domain and refusing to grant monopoly rewards, the U.S. is disincentivizing research and development.
And what's the risk there?
The fear is that this will allow foreign adversaries, particularly China, to overtake the U.S. in critical dual-use technologies like AI and robotics, because those countries might offer stronger IP protections.
It's a very logical fear. If you don't offer a strong monopoly reward, capital dries up, people stop inventing. But the newsletter offers a factual counter-narrative to that fear based on current market data. What do the actual numbers show? Is innovation slowing down because the courts are killing patents?
The data paints a completely contradictory picture to the fear narrative. According to the statistics cited in the newsletter, investment in AI and robotics is at historic, unprecedented highs, despite these doctrinal contractions in the courts.
Give us the numbers. How robust is this R&D?
Let's look at the global patent pipelines. The European Patent Office, the EPO, saw a 10.6% growth in AI-related patent filings in 2024 alone.
10% in 1 year.
Yes. Filings specifically for machine learning, image recognition, and neural networks have been growing at an astonishing average annual rate of 28% since 2019.
28% growth.
It's huge. And on the robotics side, the analytics firm PatSnap tracks over 530,000 active patents in the humanoid robot motion control space, with tens of thousands of new filings every single year.
So the evidence suggests that the incentive theory isn't failing. It's just adapting to a new legal reality. Companies are still pouring billions into R&D. They're just finding new ways to monetize it.
The money is absolutely still flowing.
Which begs a huge question. How is the rest of the world handling this? Because AI is a global arms race. Is the U.S. the only jurisdiction aggressively pushing this stuff into the public domain?
This is a crucial comparative point in the newsletter. Other major jurisdictions are actually achieving the exact same result, expanding the public domain to allow AI training and development. But they are doing it through vastly different legal mechanisms.
How so?
Well, the EU, for example, took a statutory approach. Under their Digital Single Market Directive, specifically Article 4 and the new AI Act, they created an explicit text and data mining exception, a TDM exception.
Meaning they just passed a law that says it's okay.
Yes. It legislatively allows AI models to train on copyrighted data, though they do offer rights holders a mechanism to opt out.
So the EU didn't wait for the courts, they just legislated the solution.
Exactly. And Japan went even further. They enacted Article 30-4 of their Copyright Act, which is widely considered the world's broadest statutory exception for text and data mining.
Right.
It explicitly allows AI training on copyrighted works for non-enjoyment purposes. They decided at a national level that AI training is a public good.
What about China?
China doesn't have a specific TDM statute, but they are using pragmatic enforcement and fair use principles to signal strong protection for their domestic AI developers, ensuring they aren't bogged down by copyright claims.
So if I'm tracking this correctly, Japan and the EU passed sweeping laws to make sure AI companies can build their models without getting sued into oblivion over copyright.
Right.
But in the US, Congress hasn't passed a law like that. Legislation like PERA is stalled in subcommittee. So instead of Congress doing it cleanly, the U.S. courts are doing it messily, case by case, by stretching these 4 defensive IP doctrines.
That is a perfect summary. The U.S. is achieving the exact same macroeconomic policy outcome, ensuring the raw materials of the digital age remain in the commons to fuel the AI boom, but it's relying on the common law system.
So it's a slower process.
It's flexible, but as you said, it's messy, expensive, and unpredictable, depending on which circuit court you happen to find yourself in.
Okay, we've covered massive ground today. We've talked high-level constitutional utilitarian theory. We've broken down billion-dollar court cases. We've looked at the global legislative landscape.
We've covered a lot.
But I want to bring this down to earth for our listeners. If you are running a tech company right now or advising a startup or your general counsel defending against an infringement lawsuit, what do you actually do with this information today? What is the playbook?
This is where the theoretical rubber meets the practical road. The newsletter emphasizes that this shift in the courts creates a highly asymmetric legal landscape.
Meaning what? Who has the advantage?
Meaning, this is an incredible era for tech defendants and a very difficult, frustrating era for plaintiffs who are still relying on legacy IP strategies from 20 years ago.
Okay, so if I'm defending...
If you are defending against an infringement lawsuit, the playbook is clear. Lead with these defensive doctrines and lead early.
Give me a scenario. If I get sued by an author for training my AI on their publicly available blog posts, I don't wait for a 3-year trial.
No, absolutely not. You move to dismiss at the pleading stage using Section 102B, arguing that the AI only learned the uncopyrightable method of language.
No, it's a patent suit.
If a legacy software company sues you over a broad patent, you immediately file an Alice motion citing the recentive case, arguing their patent is just an invalid, abstract idea of generic machine learning.
And robotics.
If a robotics company sues you over the shape of your drone, you invoke the traffic's functionality doctrine. These defenses are winning, and they are winning early in the litigation process, potentially saving companies millions of dollars in discovery and trial fees.
But let's flip the script. Let's say I'm the builder. I'm the scrappy startup founder who just invented a brilliant new AI architecture.
Right.
If the courts are knocking down patents and copyrights left and right, how do I build a moat around my business? How do I stop Microsoft or Google from just taking my idea?
You have to fundamentally shift your moat. For patents, you stop wasting money trying to claim broad, abstract applications. You focus your patent prosecution strictly on narrow, highly specific technical improvements to the hardware or the model itself, like physically tying the neural network to an ASIC chip, as we discussed with the USPTO examples.
Okay. And for trade dress?
For trade dress, you stop trying to own the physical shape of the robot and focus your brand identity on distinctive, arbitrary logos and color patterns that have zero functional use. And you protect your closed model weights fiercely with compartmentalized security.
But what about the stuff you have to share with customers?
What do you mean?
Well, if I build a B2B SaaS platform, I can't patent the software because of Section 101, and I can't keep it a trade secret because the customer can see the UI working, just like in Turret Labs. How do I protect my business from a customer who wants to reverse engineer my tool?
The author of the newsletter points to the most fascinating twist in that fitness DVD case we started with, Tracy Anderson v. Roop.
Oh, the workout video.
Right. We spent a lot of time talking about how Tracy Anderson lost her copyright claim because her workout was an uncopyrightable method. But there is a crucial footnote to that story that reveals the future of tech protection.
What's the footnote? She didn't lose the whole case.
No, she didn't. She lost the copyright claim, but she kept the breach of contract claim.
Contract claim.
The defendant, Megan Roop, wasn't just a random person who bought a DVD. She was a former employee who had signed specific employment and confidentiality agreements. The parties ended up settling that contract claim confidentially.
Oh, contract law.
Exactly. This is the ultimate emerging moat for technology companies because statutory intellectual property, copyright, patent, trade dress is failing to protect these new, highly functional digital creations. Companies are being forced to rely heavily on contract law.
So talk about what, user agreements?
We are talking about dense end-user license agreements, or EULAs, incredibly strict non-disclosure agreements, massive terms of service documents, and restrictive API access agreements. Contract law is stepping up to do the heavy lifting that IP doctrine used to do.
So if I build an incredible AI workflow tool, I might not own the copyright to the algorithm itself, but I can force anyone who logs into my platform to sign a digital contract promising they won't copy it, reverse engineer it, scrape its outputs, or use it to train a competing model. And if they do, I don't sue them for copyright infringement. I sue them for breach of contract.
Precisely. If you are a builder today, NDAs and terms of service are no longer just polite legal formalities. They are the absolute mandatory bedrock of your business. If a customer or a partner can see your software functioning and they haven't signed an NDA or a EULA, you have essentially forfeited your rights to protect that functionality.
All about the contract.
The contract is your only remaining wall.
Wow. If contract law is actively replacing intellectual property, it means the fundamental rules of innovation aren't really being written by Congress or the Constitution anymore.
It's a huge shift in power.
Yeah. They're being written in the terms of service agreements that we all just scroll past and click accept on without reading. We started this deep dive talking about how the courts are pushing all these fences outward, expanding the public yard where AI and robotics can freely roam and train.
Right.
But if that public domain is increasingly walled off by millions of private contracts, API limits, and strict EULAs, I mean, how public is the future of AI actually going to be?
That is the paradox.
It's a massive paradox.
Right.
The federal law says the ideas are free, but the private contracts say you can't touch them. That is something every founder, developer, and user needs to seriously think about as we move into this next decade.
It is the defining legal and economic tension of the next era of technology, without a doubt. Thank you for walking through this incredibly complex landscape with me.
Thank you. Led by Jack Russo. Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at jack@computerlaw.com and his team at www.computerlaw.com, where the newsletter we refer to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.